law degree. And then primarily I was a prosecutor. I was a state prosecutor for a long time. Then I was a federal prosecutor for a while. And then I was an international prosecutor in Eastern Europe, prosecuting cases, war crimes, things of that nature. And then I also went to Afghanistan as a lawyer for the Department of State, lived in Afghanistan for a while. And then a couple of years ago, Governor Inslee appointed a judge in my county. There had been a retirement. And this woman was not a good fit for the county. She started making some decisions, the county, and I particularly didn't like, because I was a deputy prosecutor there. She was letting somebody who'd shot her boyfriend 6 times. I'd asked for $500,000 bail. The public defender had asked for $50,000 bail. She let the young woman out for $5,000, so basically $500. And she got out and sadly committed suicide shortly thereafter. And had she remained in the jail, she would have been on suicide watch. So I ran against her, won by 15 points, then ran unopposed again for my term. And so that I'm a Superior Court judge right now. So I'm on the criminal rotation. I do mostly criminal cases right now. And I've done civil cases, protection orders, real estate cases, dissolution, divorces, things of that nature. So the reason I'm running for Washington State Supreme Court is there's been some troubling decisions coming down from our Washington State Supreme Court. But we were all prepared for that. We knew we had a fairly liberal Washington State Supreme Court. So for the last 40 years, the governor's been appointing judges in our state. So Oliver Wendell Holmes said, to understand the law, you have to understand history. So before we were a state, we were a territorial government, and the governor appointed judges. And so a lot of people felt that the judges were political, that some of them were corrupt. So they specifically put in our Constitution, the state Constitution, that judges would be elected, because they wanted the public to vet the people who wanted to be on our highest court. But then a tradition started about 40 years ago, where judges would retire and then the governor would appoint. And then a tradition kind of crept into the things where if you were appointed by the governor, when you retired or quit, you would let the governor appoint your successor. So 70 to 80% of all the judges, Superior Court, Court of Appeals, Washington State Supreme Court, have been appointed by our governors. The last time we actually had somebody who wasn't appointed by the governor, who had a dissenting type of view, was Richard Sanders. And he got off the court around 2011. So from all that time, all the judges think all the same way, because they've been largely appointed by the same type of person. And this has had an effect on our law. But in the last few years, they've decided that they were going to use the rules of procedure. So the rules of procedure, the legislature will pass a law, and then the courts will have to implement that law through their procedures. And if you actually read the cases that have interpreted these rules, they describe it as mechanistic, that it's just like a machine. And then they interpret how to apply that. But then they started making procedure that contravened the law. And the biggest example, and the one that was most troubling for me, was in juvenile cases. So in juvenile cases, the legislature says that if a minor violates their probation, that we could go and get a warrant and have that person brought in. And when I was on the juvenile rotation, we would get these girls 14, 15, 16 years old, and older men would get them addicted to drugs, use them for sex, and then some of them would be turned to prostitution. They would start committing crimes, then they would come before me. And then I would make sure that they got the help that they needed, that they were in a safe place, that they got drug treatment, and we were able to turn some of these lives around. But the Washington State Supreme Court didn't like warrants for minors, even ones that were on probation. So they nullified all the warrants that were out there. And they said we could only issue warrants in cases of specific danger. And they actually addressed a case where a young woman, a judge, decided he would not follow that rule. And he put a warrant out because a young woman was suicidal and he wanted her to get treatment. And they said, no, he did not have that power because she wasn't a danger to anyone else. If she didn't do her drug treatment, she wasn't a danger to anyone else. So that really bothered me. Then there was the case, the Blake case, where they decided that even though since 1981 or 82, we've had a drug statute on the books, a felony drug statute. I did a lot of cases during the meth epidemic as a prosecutor. We were able to get some people turned around, get them treatment, make sure that they were on community custody, which is similar to probation. And then it went up and they found it constitutional. State Supreme Court found it constitutional. Then about 13 years ago, it went up again. Again, they found it constitutional. Then about, was it 5, 6 years ago? Yeah?
2021.
Yeah. So it went up. And then all on their own, making arguments that hadn't been made by the attorneys, they decided the drug statute was unconstitutional. And they legalized things like methamphetamine. It was not illegal to possess methamphetamine, fentanyl, which is incredibly dangerous. I don't know if you guys have been to Seattle recently, but you can walk down the streets and see people shooting up in public. And so for a few years, it wasn't even legal. Now the legislature has made it a misdemeanor, and that doesn't work. Because the way it works with drugs is you get arrested with drugs, they have to be sent to the lab. The backlog is 1 year, 2 years, and the statute of limitations is only 2 years on these things. So these cases get immediately dismissed because the prosecutors can't prosecute them until the labs come back and said that they actually are drugs. And they're not being addressed. So the Supreme Court, because of ideological and political beliefs, nullified the statutes on drugs. And I don't think they're helping anyone. They're not helping the citizens. They're not helping the defendants, because sometimes we were able to get them into treatment, make sure that they stayed out of trouble. So now we can't even do that. There's other rules. They're trying to get rid of the bail requirements. So the state constitution says that if you commit a Class A felony, so think murder in the first degree, forcible rape, rape in the first degree, things like that, you don't even have to be allowed to post bail. You can just be kept until your case is resolved in incarceration, because these people are particularly dangerous. And the legislature passed laws on how to implement that. So if I say somebody is going to be held without bail on a Class A offense, rape in the first degree, then they get another hearing, and then they get an immediate appeal to the Court of Appeals on bail alone. So now they're considering a rule, and they've taken that out. It's in the rules now, but they're taking that out. I won't even be able to follow the state constitution or our laws. They've decided that they do not want people held pre-trial, and they're going to make it impossible just about to hold people pre-trial. They're using the rules to undermine the criminal justice system. So that's why I'm running for state Supreme Court, because we need people in there that will call them out, because nobody hears about these things. The lawyers talk about it. I talk about it with my friends that are still prosecutors and my friends that are public defenders, but it doesn't get out to the public. You don't hear about it in the newspapers. You don't hear what the state Supreme Court is doing. So we need people up there with common sense that will get up there and say, no, this is what's going to happen. Because when they propose these rules, judges like me, I've done this, we write in comments saying, you can't do this. If you do this, this is gonna be the inevitable outcomes. And you know what? They don't care. Deborah Stevens, who's currently up for election, she's the Chief Justice, she actually did an interview, I guess it was about 5 months ago, after her state of the court address, when she was asked about all the effects of these rules, said, that's not our problem. So that's why I'm running for state Supreme Court. Please, if you go on those envelopes or if you go on our cards out there, there's a thing where you can do with your camera, the QR code. It'll take you right to my website. You can read more about my background, more about my beliefs and my experience. If you have any questions, I'd be glad to answer them. I'll turn it over to Judge Larson.
Thank you, Judge Stevens. Thank you. Thank you, Judge Stevens. I'm Judge Dave Larson, but I'm retired Judge Dave Larson, but my retirement lasted about 30 days. So a little bit about my background. I grew up in Federal Way, essentially, and graduated from high school, worked full-time, went to college, worked full-time, went to law school. During law school, I worked in the Pierce County Prosecutor's Office my first 2 years. First year in the misdemeanor division, then in the civil division as an intern. So in the second year, I was actually writing briefs on civil rights cases and that type of thing, lawsuits against Pierce County. Third year, I went to a private firm that also did government liability work and also insurance for insurance companies. One of the cases I worked on was the racketeering case. Anybody remember George Janovich, Pierce County? Anything? Probably not, because it was, but basically in the 70s, it was mafia who had infiltrated the Pierce County, and one of the cases I worked on as an intern involved an assassination attempt on a liquor control agent who then sued the county for civil rights violations because the sheriff was involved, and also they were seeking protection money and burning down topless places that didn't pay protection money. And a guy named Anderson was suing because he owned what's called the Back 40 Tavern. So that kind of stuff, those kind of cases I worked on in law school as an intern. Then in both at the prosecutor's office, and that case got migrated over to the firm I was working at. Got to work on it there too, along with other cases. And it's cases I worked on as an intern. They gave me so much responsibility. I did everything but appear in court on motions and take depositions. But otherwise, I was doing all the same stuff a lawyer would do when I was still in law school. And ultimately, that landed me a job because one of the companies that sent them work was Safeco. So that landed me a job with Safeco Insurance Company as one of their staff trial counsel. And so I tried my first trial a month after I became a lawyer, and then worked for a private firm in Tacoma for 3 years, and then I had my own firm for 10 years. And I did work where I represented people who got sued. And then ultimately I went on with a firm called Williams Kastner because I wanted to be a Little League coach and a father and stuff. So owning your own business, and especially a law firm, is busy. And so I stopped trying cases and went on board with them as of counsel, which means I'm not an associate. I'm too old to be an associate, and I don't want to be a partner. So they call you of counsel, kind of an honorary position. But I would work on the cases that they gave me because I didn't want to have to generate work. But they had me doing litigation and where you had to bring 25 chairs to a conference room to take a deposition, really complex construction litigation. And then also I was a part of a national counsel team where I was chair of a department that managed the discovery for 15,000 products liability lawsuits nationwide. And so I went from that to traffic and misdemeanors as a municipal court judge. So how did I do that? So I was president of the school board in Federal Way, and our court, and I'd lived there forever. I lived there 58 years before I moved to Ellensburg after I retired. But so I'm kind of a staple there. So they asked me to come over and fix the court. So 18 years later, it's one of the most purpose-driven things I've ever done. Really kind of the things you see in the news about addiction, mental illness, we deal with that directly. Because the Superior Court, there, Judge Stevens is felonies, those kind of things. And one time I was in front of a bunch of students. It was kind of a career day, so I told them about my career. One of the students said, "You don't handle very important cases, do you?" And I said, "Well, actually, I handle the most important because I can get somebody before they graduate to felonies." My motto is I run a repair shop, not a junkyard. The idea is to make people's lives better when they come to court. So I'm not gonna bore you with all the details, but I've been recognized nationally with some of the strategies I've come up with, especially regarding early intervention. Because if you look at all the programs you hear about in the news and hear about, all the programs assume somebody's already out of control. We wait till they're out of control, till they're addicted, they're living in the woods, they're creating crime after crime, and then we start intervening. And one of the things I say is we don't need to be tougher on crime or softer on crime, we need to be smarter on crime. And that's how we address it. So early intervention, getting somebody the very first time they're there, potentially they're still housed, they're still employed, they still have something that we can work with them on. And it's a struggle, and we've made some progress with the legislature, worked with both sides in the House and the Senate to get stuff done, and gotten a number of things done over the years, but about 40% there. So why would I want to run for the Supreme Court when I retired? So I had no intent on running. In 2024 I ran, and maybe you remember voting for me, but I lost by 0.61% to a person that outspent me 3-1. Was supported by every Democrat ballot catcher in the state, and ran negative ads on me and everything, and still I lost by 20,000 votes out of 3.6 million. And so 20,000 votes out of that many is 0.61%. Outside of King County, I won 56 to 44%. So it was a landslide outside of King County. In King County, I lost by 30%. So when all the vacancies came up this year, like I said, I moved to Ellensburg. My son was a police officer over there. 3 of my grandkids are there. The houses are cheaper. And so I moved over there and had no intent on running. And then the vacancies come. People were trying to get me to run. And then ultimately the rule that Judge Stevens talked about making it harder to issue a warrant for somebody if they don't show up for court. That's kind of the impetus. Like, you know, there's too many things at stake. And, you know, and the other thing, like, that I kind of joke about, but it's absolutely true. The only thing at stake is representative government and freedom, but other than that, there's not much at stake, right? So our founders were willing to give up their lives, fortunes, and sacred honor. And all I gotta do is put 30,000 miles on a car, meet a bunch of nice people, and get told I'm full of crap every once in a while, right? So it'd be embarrassing not to run, and so I did it out of sense of duty, really to, because it's, to me, it's too important. And my 5th grandchild was born also, and kind of like when he's 12, 13, 14, whatever, and he asks, hey, Grandpa, what did you do to try to make things better? I'm not gonna say I was sitting watching TV. I used to drag race, and I used to drive a dragster in NHRA competition all over the West Coast into Canada. I stopped in 1999, but in 2024, I went back to get my license, to get eligible for my license again. So I think I'm the only judge in the world that's eligible to drive a dragster in NHRA competition. But the reason I brought that up is because I love cars, and I was about to get a street rod and go to car shows and polish it and do all that stuff. But instead, I bought a 2023 Honda Accord that I'll drive into the ground, driving around the state. But let me tell you how I see elected office, and where I think, you know, one of the things I say is we're so interested in getting our way that we've lost our way. And we're so far out from the way we're supposed to be governed that it's absolutely silly. Article 1, Section 1 of our state constitution says all political powers inherent to the people. Governments derive their just powers from the consent of the governed, and the purpose of government is to protect and maintain individual rights. Our system of government is based on a people that want to pursue duty and responsibility, not power and control. And we've deceived ourselves, all of us have deceived ourselves into thinking that it's about power and control. And one of my sayings is, I don't know what came first, the chicken or the egg. All I know is a bunch of chicken feathers we got to clean up. There's a mess. I don't care who caused it, but we have to stop it. We have to stop this notion that it's about power and control. Because the greatest generation understood duty and responsibility more than any of us. And you can see how life functioned when you focus on duty and responsibility. I've created a program called How Freedom Works. It's based on 2 rules. Rule 1, love the freedom of others as much or more as you love your own. And rule 2, it's more important to do right than it is to be right. And the reason I created those rules is we're in a mode now where my rights are more important than yours, and I'm gonna be right even if I'm wrong. I'm entitled to my opinion, and you're entitled to my opinion too, right? But government office, the way I see elected office, I explain it by a story, because I've been very involved in civics education. I've helped teach a class at Todd Beamer High School in Federal Way for 18 years while I was a judge. And every year I'd start the class, what's most important in protecting freedom? And the students would go around the room, police, courts, constitution, military. The answer, the belief that it's important. Because if you stop believing it's important, it's okay to think your freedom, your freedom, your freedom, and when it's about power and control, that's the idea, is my side has to win, or at least your side has to lose. And that's the mode we're in right now. And so how do the courts fit into this? How do the courts fit in? We're supposed to be the lighthouse in the storm and not a ship lost at sea. We're not supposed to be immersed in politics where it's up to our elbows. We're up to our elbows in politics. We're supposed to be that constant in the system where there can be all this political rancor going on, and the more the better. If our institutions are functioning properly, the more disagreement we have, the better it is, because we can end up with laws that we all need instead of laws that only some of us want if we're willing to reach consensus. When it's about power and control, you only end up with laws that only some of us want, and then you're in the courts fighting about the laws that only some of us want, the other ones don't. That's what we've done with the courts, is we've made them so political. And we need to stop that. It needs to be the most boring branch. I always joke we're the offensive linemen of government. We only get noticed when we jump off sides, right? And that's the way it should be, is we should be boring. We should be the branch of government that's constantly trying to put itself out of business. Because we don't want dispute, we don't want crime, we don't want those things. But we're so in love with our dogma and the way we do things that we create more problems in cases, especially family law cases, criminal cases. Some of the ways we approach things are more trouble, create more problems than we solve. And one of the things that people don't really know, because we're very mysterious in the judiciary, is a lot of what the Supreme Court does is create rules that operate the courts, both administratively and administrative rules that manage courts. They create rules that decide how cases are handled, both criminal and civil. They make rules on evidence, what evidence juries hear. They make rules on appeal. They make rules on how a lawyer becomes a lawyer. All kinds of things that people don't really appreciate. They just think it's the decisions the court makes. The thing I bring in this particular race is 41 years of experience, 18 of it as a trial judge and 23 years as a trial lawyer in state and federal court. My peers rated me AV preeminent as a trial lawyer, which means that's the top, you can't get better. And then as a trial judge, I've been rated exceptionally well qualified. And I bring that plus 10 years of teaching at judicial college, 16 years of running a court, 17 years of successfully working with both sides of the aisle in the legislature. And my opponents, there's 3 of them. One came out of nowhere. He was a lawyer for a large law firm in Seattle, or a medium-sized law firm in Seattle. And he was an appellate lawyer, never met a judge. The other one is a judge in Thurston County. She's only been a judge for 6 years. And the ratings by the lawyers are not good. And then the third person is the person that Governor Ferguson appointed to the position 1 month before filing. He's only been a justice since April. And he's now considered the incumbent. In fact, with the reporter the other day, they were talking about judicial experience, and one of the reporters said, well, there's 3 of the 4 of you have judicial experience. I said, 3? Well, Justice Angeles. Well, he's been on the bench 2 months. And they're already equating him as an incumbent. The thing about him, and I've rung the alarm bell, and whether it takes any traction or not, whether people appreciate it or not, I hope they do, is that judicial independence is something that's essential. The courts are supposed to be a backstop for abuses by the other 2 branches, and not an open gate to let it happen, right? And Governor Ferguson, the first appointee this year, and these are nice people, I've met both of them, the 2 people he's appointed to the Supreme Court, nice people. But the first one he appointed, Colleen Melody, which is in position 1, she was a senior staffer at the AG's office, worked directly for him. Okay, so she was a subordinate to him. The guy I'm running against, a guy named Theo Angeles, the guy he appointed, has been a campaign contributor to Governor Ferguson since 2009, has already given money to Governor Ferguson's 2028 campaign. He's also contributed to Monka Dingren, Jamie Peterson, all the names that you hear about the income tax in the case and other legislation that comes before the court. And he's even contributed to Nick Brown, the Attorney General. So, so they're not even trying to hide the fact they're trying to control the courts. And the court, in 2018, I was given the President's Award by my Judges Association for my work around the state protecting judicial independence in municipal courts that were threatened by either mayors or city councils or whatever coming in to try to control what the courts do. And judicial independence is so essential to our freedom. It's underestimated. But the ability to have an independent judiciary, a judiciary that's going to decide cases based on the law and the Constitution and not regard to politics or personal favor, is so important because our founders, when they created our government, knew that power in any one place would be problematic. And when you allow power to coalesce, either by friendship or alliance or whatever, it always turns out bad. That's why we have to have a court that's independent. But I think at this point we turn to questions, and the other thing I wanted to tell you is how I see government, how I see my role. I was with a bunch of students, and this one student asked me, or asked all of us, there was elected officials there, when did you feel closest to your position? And the other elected officials went down the line and talked about something they did in their official capacity. When it got to me, I said I was in the back of a line at chili cook-off. And this person came up to me that knew me, called me judge, talked to me for a couple minutes and left. After the person left, the person behind me said, "Hey, you're a judge, just cut up in front of the line." I said, "Actually, when I don't have my robe on, I'm like anybody else." And I told the students, the reason I told you that story is my position is that of citizen, like anybody else. I play a role as a judge. It's a responsibility, not a power. I'm a servant, not a master. And that attitude breathes life into Article 1, Section 1 I talked about earlier. And the attitude that somehow I'm special because I'm elected, or I have more power, that I'm above you, that is a direct assault on Article 1, Section 1. And that's where we've gotten, where you go to a city council meeting, school board, or at any branch, and you're treated like a subject and not a citizen. That's part of the problem we have today. Anyway, thanks.
Well, stay standing with your mic, and then Judge Stevens, if you could hop up. So we'll have questions, and then you can both answer. So, anybody have a question? Who said I do? Oh, there we go.
Hi. I have a question about you, Dr. Larson. You just talked about how the Supreme Court mostly makes rules, administrative rules, etc. And Judge Stevens, you talked about something that was changed in 2021 about drugs. Was that a rule, or was it a decision from a lawsuit?
All right, so the Blake decision was a decision about drugs. And when I was talking about the rules, I was talking about the warrant.
Okay.
Yeah.
So how would the Blake decision, how could that change? Is there, would another lawsuit have to come and it would just be a decision that way?
It'd be easy. The legislature could just make it a felony again. So what it was is they said that it didn't have an intent element. The U.S. Supreme Court says that you can have felony non-intent crimes. So they said it was under the Washington State Constitution, that it was unconstitutional, not under the federal Constitution, because it would have been constitutional. That's probably in the weeds for you, but the legislature could fix that anytime they wanted to.
That case is an example of what the role of a judge is. Like personally, I did not like the fact that it was strict liability. In other words, all you do is have drugs on you. It didn't matter whether you knew it or not, you could be convicted. That's what strict liability means. I didn't like that, but I would have been in the dissent upholding the law the way it was written because the legislature decided that. And the way it was remedied, as Judge Stevens said, is the legislature, now it's a gross misdemeanor instead of a felony. And that's when in 2023, but for 2 years, 2023, they made it a crime again, but only a gross misdemeanor. For 2 years, drugs were legal, and the effect we saw in our communities and our courts was significant. And what the Supreme Court did with their decision was the same thing Oregon voters did with popular vote, was get rid of drug laws, right? And as Judge Stevens said, the thing that's so troubling is that, and one of the justices called out the majority on this, that the justices came up, as Judge Stevens mentioned, arguments the lawyers didn't even come up with to declare the laws unconstitutional, which is now that if you wanted the definition of activism, that's activism.
Right.
Hi, I just want to know, what are your thoughts about this 250th year since our declaration? Both of you.
You want to go, okay, well, that's something that's very dear to me. The thing that's so troubling is it just seems like it's a footnote. When that revolutionized how we see ourselves in relation to government, and it's been kind of, you know, there's a guy named Learned Hand, and and I wish I'd memorized his speech on the love of liberty, but we've fallen out of love with liberty. And if we were more in love with that, we'd really appreciate that. And one of the things Judge Stevens talked about, appointments of judges, one of the grievances in the Declaration of Independence was the king got to appoint the judges, right? And, but it's troubling to me that there isn't just a lot more. I mean, look at the World Cup, how the fervor around World Cup. That should be double about the Declaration of Independence because it's so significant. One thing I think we don't appreciate being born into what we have is how special it is and how unique it is for us in history. Tyranny has always been the default. This idea that government answers to the people and not the other way around is revolutionary. There's been a struggle for thousands of years, and that's between people that want to be free and people who want to dominate and control. And we said, we're going to be free. And what happens if you're not constantly vigilant about it and you don't love it, you get sucked back into tyranny. And that's what's happening to us now, because that's the default. Human nature is such that we will default to try to dominate and control other people. And being in love with those principles is important. Our founders in our state constitution put a provision in Article 1, Section 32 in our state constitution that says a frequent recurrence the fundamental principles is essential to individual right and the perpetuity of free government. And simply put, we got to bathe yourself in those principles. If you don't, you lose them. And that struggle, if you don't push with people, the problem is that people that just want to be free, they just want to live and love, live their lives, they just mind their own business. People that want power and control, keep encroaching and encroaching and encroaching. And the reason that provision's in there in state constitution is in that 100 years between the federal and state constitution, our founders witnessed some of those encroachments. And the problem is if you don't push back the minute somebody starts doing that, then we lose the luster. The Declaration of Independence loses its luster. That document, that seed it planted, made us go to the Civil War to end slavery, civil rights movement, women's right to vote. All that seed that was planted led to all that. And my concern is that we have lost love of that concept and don't really understand the consequence. And I'll end with, I ran an art contest out of my court in cooperation with the school district and our arts commission in the city. In 1 year, we have 3 recipients at each grade level, or each school level, grade school, middle school, high school. So there's 9 recipients each year. All 9 of those students were first generation Americans. Because their families came from places that didn't have what we have. And so we have to fall in love back with liberty. So that's a long answer to your short question, but.
My answer to that would be, remember 1976? Remember?
I do.
I mean, it was right after Watergate, there was all kinds of dissension, Vietnam War and everything like that. But everybody came together in 1976, and we celebrated the birth of this country. And it just seems, I don't feel that. It's in a few days. I mean, the huge buildup that was in 1976. So, I agree. I prosecuted in Europe. And so the system I prosecuted under, you've heard about double jeopardy, right? You can't be tried twice for the same offense. You've heard of the Fourth Amendment, that you can't do searches. The Fifth Amendment, you have a right to confront your witnesses. In Europe, they don't have any of that. If the prosecutor takes you to trial and he loses, he can appeal that. When I would do trials in Europe, I would submit a list to the judge, and then the judge would pick which witnesses the judge wanted to hear from. And if he didn't want to hear from them, it'd be by affidavit.
Don't forget the presumption of innocence.
Yeah, the presumption of it. And you could be driving around Europe, and you'd see a law enforcement officer on the side of the road with these flashlights with a light. He'd wave you over, and then he would search your car for no reason whatsoever. I totally agree. People don't understand the history of the United States and how different it is here. The right to jury trial doesn't exist in Europe and England, Commonwealth countries, and they've diminished it quite a bit. But they don't even have that. It's a judge, and if it's a major case, you get 3 judges. And you don't even have to be unanimous. You get 2 of the judges and you're convicted.
And you have to prove your innocence.
Yeah, so people don't understand how unique in the entire world history the United States is, how important our freedoms are, and how we fought a war in this country. You know, more people died in that than died in World War II. I mean, to make sure that people were free in this country. It was imperfect, took a while, and we're still working on it on certain ways and stuff like that. But you would think people would just be celebrating, even if they just celebrated like they did in 1976. So that'd be my answer.
Well, the Pledge of Allegiance ends with liberty and justice for all, because you can't have one without the other, right? And that's why the justice system is so important. And to what Judge Stevens is talking about. And when in street law, the class I taught was called street law. When I taught the Bill of Rights, I told the students, and it said, think about it hard. Every one of those rights, if you break up each right in the first 8 amendments, every one of those rights were as a result of abuses in history that were prevented by having that right in place, that still exist.
Oh, okay.
Yeah, I'm sorry, I get paid by the word.
Okay. I guess I'd like to start with Judge Stevens, and then maybe you could add on to it. I'd like you to go back, if you would, to give examples of specific things that you offered in the courts regarding helping preventative things, because each of you talked a little bit about terms trying to interact, if you will, or have some kind of make a difference with these young people in particular that come in and they're down the road to some serious criminal activities. So if each of you could speak to things that you've done on the preventative level. Thank you.
Well, so I bet you've done this too. So I had this young juvenile, and he'd gotten into some trouble. It was pretty low level and everything like that. But you could tell this young man didn't have friends, that he got picked on. I had a lot of empathy for him, because as a kid, I wasn't into sports. Everybody said I read too many books and stuff like that. And so I had a lot of sympathy for him. So when his case was done, completely done, because I can't have any, it would be called ex parte contact, I have lunch with this kid every now and then. So he has somebody he can talk to, somebody he can see that went through some of the same things that he is going through right now. But I'll tell you a story of Otto. So Otto, it was a really, really thin case. I don't think most prosecutors would have taken it to trial. But Otto had a serious drug problem, methamphetamine, and he kept being prosecuted. They'd give him deals, tell him to go into treatment, and he wouldn't do it. And then he would pick up more methamphetamine cases. So I had this case, nobody thought I could win it, but I really wanted Otto to get help. So I took it to trial, and I couldn't believe it, I won. So then about a year later, maybe it was 2 years later, and I'm going into the courthouse as a deputy prosecutor, and he's getting screened because I had the badge, so I could just walk right through, and I see him in line, and I think to myself, oh man, because when somebody's convicted by a judge, judges will often, as I do, make sure that they report back to the court. Instead of just giving him over to DOC for probation, where DOC takes care of them, I can retain jurisdiction. And then I make them come back and I make sure they're doing what they're supposed to be doing, or they're gonna do some jail time until they get with the program, right? And so we retain jurisdiction in that case because judges are willing to do that when it's a trial. and not as part of a plea bargain, and he'd gotten through the treatment, and so I see him and I go, and I turned around and I actually thought I could be in trouble if he had a criminal case, because I'm a deputy prosecutor. I turned around and I said, Otto, why are you here? What have you done? I was so angry. And Otto gets this big smile and he goes, I'm here to get a marriage license. I got a good job now. I'm gonna get married, and I got to go to Otto's wedding and everything. And every so many years, I pull up his name. Otto's never been in trouble again. We turned his whole life around. We can be proactive. We have Veterans Court. We have Mental Health Court. We have Drug Court. There's a lot of times when we'll take somebody, if we think that they really want help and they're willing to work through it, we'll divert them from the criminal process and lead them. My favorite, of course, is Veterans Court. I'm a veteran myself. My wife's a veteran. She was in the Navy herself. And there's certain things. Anybody else here a veteran? So you know, when you talk to other veterans, there's this shared experience. We were really taught respect for the rule of law. We were honored, willing to sacrifice for freedom, for your fellow man. So there's something about being a veteran that just, I'm with the VFW, my wife's with the VFW, and we go out every now and to the Veterans Club, and you get to talk to other veterans. I think that's one of the reasons why the Greatest Generation, because after World War II, they all had a shared experience. The entire nation had a shared experience. Liberty was on the line. And so people had a common understanding of what was at stake. And I think we've really lost that. Really. So there's a couple instances where I've been able to help people.
So earlier I talked about running a repair shop, not a junkyard. So typically you imagine a judge scaring somebody with failure, with what failure looks like, right? What I did is inspire people with what success looks like, right? And the early intervention piece I talked about earlier, the very first time somebody's in court, that's when to reach them. We've always had crime, always will, right? It's not a group hug, warm fuzzy, it's a screening process. So when I help that person the first time, I might never see him again, great, right? Come back the second time, you ramp it up, expect more. Third time, you expect more. Maybe the fourth or fifth time, maybe you're just a criminal that also has an addiction and behavioral health problem. That's not causing it, right? You're causing it. And at that point, I say, who do you want to control your life, you or me? And then I try to always get them to turn around their life. The other thing I did in 2019, November 2019, I was like I said, I worked with the legislature. Another legislator and I arranged for 60 stakeholders to come to Olympia in a conference room to talk about solutions. And after the meeting, I met with this brand new legislator named Lauren Davis from the 32nd District, a Democrat. And she and I were commiserating, but basically what we were doing in our courts is we would put all kinds of requirements on people, kick them to the curb, and if they didn't meet them, we'd punish them. In a lot of cases, they have jobs and stuff, and then we put them in jail and they lose everything again, right? So she had been involved with peer navigators in other settings. And so we came up with the concept of peer navigators. Have you ever heard of them in courts now? It came out of that conversation. What a peer navigator is, they're trained and they're certified. They've been through the system themselves. They had some kind of behavioral health issue, an addiction or something, and now they're clean and sober and they're gainfully employed, helping other people. So that first time, so in my court was the first court to have barrier-free access to peer navigators. So if somebody comes in to pay a traffic ticket, they can talk to a peer navigator. And what that does is it gives them a confidential person to talk to about how they can get on a different path. The other thing I noticed when people come to court is the in the top 5 reasons people relapsed and came back is because they went back to their same environment, their same friends. So the peer navigators do is give them a different environment. And they get them on a path of getting employed and everything else. And so when I talked at Drug Conference a few years ago about this concept, I said, are you willing to live with the success you'll never know about? Because I'll never know whether those people that talk to the peer navigator confidentially, never came back because of success from that, right? But ultimately, Nobody's gonna come into court that first time and say, hey, Your Honor, guess what? I used fentanyl before I came into court today. Nobody's gonna tell me that. And I'll give you an example of the strength of peer navigators. As Judge Stevens talked about, we had the therapeutic courts, we had a community court. And there was one day this guy was there, he was struggling, you could tell he needed a fix. He was a heroin addict, he needed a fix. And he's in court, and we're meeting at the library in a more or less formal setting at the library for community court. And so everybody else goes around the room and talk to him, and then when it got to me, I said, you need a fix, are you hurting? And he said, yes. Brought the peer navigator, and he was 3 days away from inpatient treatment. And if 3 years earlier, if we didn't have peer navigators, he would relapse, never shown up. But because the peer navigator came in, walked with him, literally and figuratively, until he got an inpatient, he was successfully completed. So that's the kind of magic you can do. And then it's just, what I try to tell other judges, it's a change of attitude and approach. And that's free. You don't need a program, you don't need anything. Just change of attitude and approach towards people. Seeing the potential in them the very first time they're there, rather than waiting for them to get out of control and then patting ourselves on the back because we have all these solutions, like, therapeutic courts and everything. And so that's what, and I'm continuing to do those things. And there's things that I don't want you to gloss over with geeky stuff, but I've introduced what's called the sequential intercept model to Washington State, which is the gold standard to deal with criminal justice, where the different disciplines work together. And I could go on, but there's things I want to do on the Supreme Court. While all this is happening, the Supreme Court's, it's like Rome's burning and the Supreme Court's fiddling. They're not really, it's not a priority for them, what's happening in our trial courts. And the Blake case and the rule that we were talking about earlier is an example of how they pour fuel on the fire, make it worse.
Oh, we have one more question.
Oh, you shouldn't have.
No, well, I will, as soon as you're done. As soon
Along
as
that
you're,
same theme anyway, scared straight, is that like not effective anymore? I don't know, I haven't
So-
heard, but it seemed like.
So it's so variable on what works with people, and the challenge for a judge is to get in the skin of somebody and look through their eyes, what's motivating, what's causing this. And so scared straight might work with some people, it might drive people down a rabbit hole into worse. I'll give you an example that I use to demonstrate the two extremes. I had this one guy with over 200 crimes. No matter what we did, he would continue to commit crimes. I put him in jail for 2 years, 2 gross misdemeanors, I put him in jail for 2 years. Came out, committed crimes within a couple weeks after he was released, tried inpatient, committed crimes. No matter what we did, he continued to commit crimes, right? I had this other woman, the same thing, she had a number of crimes, but also DUIs. She was an alcoholic. He was also an alcoholic, he wasn't drugs. And she came up to the bench, this is back in the day before we had automation where everything's signed electronically. She was signing the papers and she was bawling because she was going to jail for a long time. And I said something to her. Well, 2-3 years later, I'm flipping pancakes for Kiwanis, and this woman comes up and says, "Are you Judge Larson?" And I said, "Is it good that I'm Judge Larson?" And she said, "Yeah," and she had a baby and a toddler. And just along what Judge Stevens talked about with his story, this woman says, "Thanks for changing my life." It was that woman. She was married, children, clean and sober. You know what I said to her? And she hung on to, "You'll get through this." That's it. For her, that was magic. For the other guy, no matter what we did. So I think some people, that day in jail changes their life. They never want to see it again. Other people, well, at least I'm not living in, at least I got 3 squares and a place to sleep. Right? And there's a story, if you go online, go on YouTube and search for Know Me Before You Judge Me, it's the story of Lalu. He talks about the jail experience, about how in some cases it makes things worse. You know, you're 5 people in a 4-person cell, you're sleeping next to the toilet. All you can talk about is where the best place to get drugs are, where the best place to steal from, and everything else. They're comparing notes. They get out. A lot of people are dying from overdoses because they're deprived of drugs, and then they go back to their same dosage and die after they're in jail because we don't have a plan. We didn't have a plan for when people got out of jail, and that's where that sequential intercept model and other things are, where you look at a continuum, and every system's working together to try to make sure that person. And really, from my standpoint, it sounds like, well, that's okay. No, it's expectations of people that you're expected to be successful. from this. But it also is a, like I said earlier, a screening process where you will identify people that are just using the system and trying to use the system to just get away with things versus really curing.
Well, with that, I guess I may have said the wrong program, but I just remember it was an ex-con.
No,
had
no,
been
that,
through it, And he came in as before jail. with
no,
the prevention.
and I guess what I'm getting at is that for youth, you're talking about with high school students and that kind of stuff, that kind of prevention. I'm sure that, and again, I didn't address that part directly, but to an extent that works, that will work, because it'll scare people. Really, the thing, I'm always trying to inspire people to have, how they can have better lives rather than scare them about what failure. The reason that's so important to me, I'll tell you my own personal story. I was raised Catholic, and when I was younger, it was always about avoiding punishment. As soon as I could, I got away from the church. And I was gone for 20 years, and then my oldest son was going through first confession and everything. So I started going back to church. And the priest that we had then was more about seeking the rewards of faith rather than avoiding the punishment of not having faith. For me personally, it's a different context, but I use that as a tool to give people a vision of what success looks like. It doesn't work for everybody though.
So around 14, I was arrested for assault, second with a deadly weapon. I was a really small kid. A much bigger kid wanted to kill me with a chair. I grabbed a knife. He kicked the knife, impaled his leg. Cops talked to him first, so I got taken to juvenile detention. This was in the 70s, so they didn't have it like juvenile detention now, where they keep an eye on the kids and they keep the older ones separate. And so a little kid in there, and I was there for a couple weeks until they were able to actually investigate the crime and say, no, he's the guy who called the police. I was the one that called the police. He was the one, and it was self-defense, so it was dismissed. I tell you, it scared the dickens out of me. And I'm not saying I became an angel. I'm not even saying I never got arrested, because like I said, I was in the Navy, so we did some stuff in other countries, our fights. But when my friends wanted to do serious crimes, joyriding, taking somebody's car, driving around, I was like, no, I don't want to be involved. I'm not going back to juvenile detention. And the attorneys and the defendants that appear before me will tell you I can be quite scary. So, I got that military voice that they trained me on. I have expectations, but then the attorneys will also tell you when it comes to alternatives, mental health alternatives, veterans court, therapeutic courts and everything like that, I'm the biggest proponent because I want people. I'm just like Judge Larson. I want them to succeed. I want them to have the ability, but we have to hold them accountable. So I can be quite scary. They don't do the scared straight anymore. I think they should, but I think they now have this model where we're supposed to hug it out. And sometimes I think you have to be, most of us here have raised kids, right? There's a time to be stern and strict, and then there's a time to be understanding. And, it comes with maturity. It comes with experience. You learn that, especially, when we all started raising kids, we were pretty young. And so we had more kids, and our parenting styles may have changed and stuff like that. So it depends on, I would agree exactly with Judge Larson here. It depends on the defendant. Some of them need one thing, some of them need another thing. But I tell you, I can be quite scary.
So Lady Justice has a sword, and it's a dull edge and a sharp edge, right? And what I tell defendants is don't confuse my kindness for weakness. I know how to use both sides.
Yeah.
Yeah.
I'm still